Going to get started on the next panel on geoblocking tools. My name's David Drummond. For the past year or so, I've been the chief legal officer of a company called Alphabet. About 14 years, for the 14 years before that, I was a similar job at Google and spent a lot of time running from governments who were chasing after me for all of the issues you're discussing today. We have a great panel, geoblocking tools. Obviously, this is when you talk about jurisdiction and figuring out how to regulate the heretofore borderless internet, these tools are, in many ways, how this jurisdiction is being defined, enforced, and then the outcomes that flow out of various decisions, whether it's intellectual property protection or regulation of content. So we have a great panel to discuss these things. To my immediate left is Graham Smith, who's a partner at Bird & Bird, who has an excellent internet law treatise online. I recommend you read it, and writes on all of these topics quite a bit. We've got Mike Godwin, of course, among other things, the inventor of Godwin's Law, which I think in this election season, the average time towards the raising of the specter of Nazism has shortened considerably in the debates around Mr. Trump. And obviously Mike's expert in all of these issues. Marketa, Trimble, who's professor of IP law at the University of Nevada, Las Vegas Law School. Has been writing on all of these topics for a number of years. And Joseph Lorenzo Hall, who's the chief technologist at CDT, who's going to start off the panel and give us a technical perspective and an overview of where these tools, how far they've come, and some of the implications. So with that, Joe, why don't you kick it off?
Hi, everyone. Let me make sure this microphone works. Yes, okay, thanks. So I'm going to give you a quick little jaunt through blocking technology or censorship tools as I talk about them. Geoblocking is not a word that technologists know. So the way I think about it is that there's an end user, there's a server, there's the cloud in between them. At any point in time, anyone with control over those things can block stuff depending on the geographic nature of where it is or where the user is or where the server is. A quick little plug, we actually study this stuff at CDT with some colleagues and have this great paper that is still under development. That's a survey of worldwide censorship techniques. It basically goes through all the technical mechanisms that censors around the world have used to block or otherwise degrade content. Getting right into it, when you make a vanilla request for content on the web, this is what you do when your computer wants to get to cdt.org. It first has to translate cdt.org, your destination, into a computer address. That's the 104.20.11.17 thing there. Then your browser can actually ask that network address for the page that exists on it, and you should get it. If you are under a regime that is doing what we call DNS blocking, they may either force the service provider or someone in between to no longer resolve or no longer answer correctly for the name in terms of the number that you need to communicate with it, which means unless you know that number off the top of your head or happen to have it lying around, you're not going to be able to make a request to that site. The Turks and others have learned that DNS-based blocking is a pretty ineffective tool. The second someone learns how to change their DNS settings to something like 8.8.8 or 8.4.4, those are the Google public DNS endpoints that allow you to get around any of that stuff. It also does mean you're sharing all your DNS queries with Google, so it does have sort of there's another edge to that sword. So that's what happens when you switch to an alternative DNS. This is meant to merely illustrate you have the same thing, you're just not using your internet service provider's domain name system in this case. However, as we heard earlier, you can have a whole set of tools usually applied at the ISP network level or a gateway level, the thing that controls access to a certain network, which may or may not correlate with the geographic area. They can block certain kinds of IP addresses, and any packets seen flying over the network for those addresses will essentially be dropped or not arrive at their destination. There's even more sophisticated tools, and you saw this if you saw the YouTube Pakistan kind of incident quite a while back now, where they actually misannounced a route, which is something that you never see as a user, and God forbid you ever have to learn about. I've written about it, and I'm happy to point you to stuff if you need to learn about it, but the routes announced on the internet can be misannounced to basically have traffic go to a different location than where it should. However, as, that's interesting. The emoji seems to have an exclamation point by it, who cares? Anyway, VPN tools, something called a virtual private network, create a strong tunnel, that lock arrow right there you see, which means that you're going through all your local network infrastructure, through your internet service provider, through anything, to another computer, essentially, and your computer will appear to come from that network location, which does not necessarily mean a geographic location. And then you're using that VPN service providers, DNS, and their own routing infrastructure, and you can get back to those places. However, we have seen lately, for example, I think Netflix is the best case of this recently, where Netflix actually now blocks whole IP addresses of what are called VPN exit points, and those are all the IP addresses of the VPN service that you may come out of, in which case, again, you're prohibited from going to any of those locations, basically on, look, we're not gonna allow anyone using those kinds of VPN tools to connect to those places. That has the unfortunate side effect of people that need to use VPN tools for whatever reason aren't gonna be able to reach your service at all. However, there are new tools being developed all the time. There's something called Streisand, yes, named after the Streisand effect, by a developer named Joshua Lund, who's part of the Signal core team. This is a revelation to many of us. This allows someone like me, probably not many of those of you in the room, although I know there's a couple of you, to with one command set up a computer on the set up your own computer on the internet that runs 7 or 8 different flavors of VPN tools. This includes things like S-Tunnel, which makes all your transactions look like credit card transactions. And the cool thing about that is that's the one thing that even non-democracies cannot block. They need those transactions to go through, or you can't really participate in the modern economic environment. The reason I say you need to use this is because this is one where this is essentially having an unlisted VPN service, so to speak. They can't enumerate the IP addresses of all these things without blocking all cloud service providers, which is not gonna happen. Anyway, I'll yield my time to anyone else who needs more of it. Thanks. Do I just go forward for you?
I'll find it.
Okay.
Great. I've called this geoblocking in context. Just a blatant plug. As you can see, I tweet under cyberlegal, and my blog is called cyberlegal.com. I'm disappointed to report that no state anywhere has yet seen fit to geoblog my blog. I thought I would start by saying a little about what geoblocking is and what it isn't, at least my perception of that, then go on to say a little about, ask why do people geoblock, and lastly, in the 7 minutes available to me, say a little something about what concerns, the type of concerns to which it gives rise. So this is my definition of geoblocking. It's probably a little narrower than the one you've just heard. A technical means employed by an internet site to detect and refuse incoming requests from particular territories. And I'm just going to unpack each of those very quickly. So a technical means, it's, as you've heard, using technology to do this, but it does have the potential to bleed over into all sorts of non-technical issues. If we look at the European Union proposed regulation on geoblocking, it is immediately talking about geoblocking and other forms of discrimination. So it starts off talking about blocking access to websites across borders, and then we have a list of other types of behavior, such as preventing orders being completed, refusing to deliver or ship across borders, price conditions and discrimination. In other words, all the sorts of things that you might expect to see actually in sort of competition law type areas. So one sees concepts of geo-blocking immediately spilling over into other areas. By an internet site, and I would distinguish actually between geo-blocking and network blocking, and I think some of what Joe's just been talking about, I would probably call network blocking rather than geo-blocking. The distinction I would make is between refusing incoming requests, which I would call geo-blocking, and network blocking, which is more to do with preventing outgoing requests. And I have my own diagram here to illustrate the two. The top one is the internet site in one country blocking incoming requests from a user in another, and the bottom one is on the user side, domestic intermediaries being used, such as ISPs being used to block at the network level outgoing requests to sites in other countries. And somewhere in the middle, you have the international intermediaries, which depending on where they're located and what they're being asked to do, you might put on one side or the other. Network blocking isn't inherently geo-specific, but often it is. We've heard the example of Turkey, and think of the Great Firewall of China, or indeed intellectual property site blocking injunctions. In practice, this is often used to prevent access to foreign sites, and so has a highly geo-specific element to it. To detect and refuse requests, I would distinguish this from geo-targeting, which is using pretty much the same technology to serve up localized content or ads in response to incoming requests. You can, the boundary is a bit fuzzy when you start to look at sort of a block accompanied by a redirect, and again in the current EU Commission proposals, you see them talking about block and redirect as a type of geo-blocking. And it is from particular territories. And here, I would say we do see a lot of confusion and failure to distinguish between territory, location, nationality, and residence. You can see it all the way back in the Yahoo Nazi memorabilia case, when the reports were skipping backwards and forwards between nationality and location without necessarily distinguishing too rigorously between the two. So why do people geo-block? I characterize it as a response. It's a response, I would say, to three potentially different things. One is the underlying territoriality of rights, the obvious one being copyright. And we see licensed copyright licensors putting in place requirements to their licensees to geo-block in order to reflect the territoriality of the right and of the licensing structures. You also have the sort of legal and reputational risk of breaching in other countries' general laws. An example a few years ago would be there was a US newspaper that blocked access to from the UK to its site because it was concerned about its reporting of a trial that was going on in the UK at the time and its exposure to the UK contempt of court laws, which are rather different from those in this country. But of course, that sort of risk has to reflect, the degree of risk reflects the reach of those underlying laws. Do they purport to apply to everything merely accessible to people in that country? Is it a targeting type requirement? And that will affect the risk and the perceived need to put in place something like geo-blocking. And then we have the response to a particular court or administrative order, the CNIL right to be forgotten, the Equistech injunction. These are examples of orders that often, in fact, I would say most often don't specifically require geo-blocking, but the party, the actor who is the subject of the order is faced with the decision on how to comply with it, and the way of complying with it often boils down to a choice between doing a global takedown of the content or putting in place a geo-block. So what are the concerns that can give rise to this? Obviously, geoblocking is seen as something which gives rise to balkanization of the internet, a splitting of the internet into national territories. The concern is that poorly formulated rules, mere availability, mere accessibility rules, targeting rules that are often or can be mere accessibility rules in disguise, will over-incentivize geoblocking. And it's no surprise, I think, that governments have struck back. The problem, I think, the issue, is whether in their state's enthusiasm or even desperation to recapture the borders that they had in the physical world, are they putting in place porous borders that are equivalent to the physical world borders, or are they going further than that and effectively creating Berlin walls in cyberspace? And the distinguishing feature of the Berlin Wall, of course, was that it was designed not to keep people out, but to keep people in, both physically and insulating them from noxious foreign influences and information. And I'd like to leave you with the thought that if what we're doing is risking creating Berlin walls in cyberspace, that by keeping information out in cyberspace, we're keeping people in. Thank you.
Good morning. So in my 7 minutes, I will talk to you about circumvention of geoblocking. So we heard from Joe the definition of geoblocking, and I will talk about circumvention of geoblocking, meaning any means used to evade geolocation and pretend as if one were located in a location where somewhere is actually not currently present physically. Now, evasion or circumvention of geoblocking can be achieved in various ways. In the old days, when geoblocking tools relied only on IP addresses, circumvention of geoblocking, of course, consisted of spoofing your IP address. But as geoblocking tools have become more sophisticated now, of course, circumvention tools will include evasion of Wi-Fi signals, GPS signals, and so forth. Examples of circumvention tools include VPNs, the Onion router, and similar services. Now, I would distinguish two types of circumvention. One that's done for the purpose of appearing as being somewhere else, anywhere else, right? So when you think about free speech activists, political activists, they might not care where they appear to be. They just don't want to appear as if they were where they actually are physically. The second type is the type of circumvention that many people engage in, even in democratic countries, which is the circumvention for the purposes of looking as if one were located in a specific different location. Example, right, I want to watch my favorite BBC shows that are not available on BBC America, so I circumvent geoblocking to appear as if I were located in London to watch those shows from there. Now, the ease of circumvention is amazing. When I started writing about this in 2010-11, many people knew of geoblocking, but very few people in my audiences knew about how to circumvent geoblocking. Today, it's the opposite. Most people don't know of geoblocking and certainly do know how to circumvent geoblocking. And if they don't know, they usually learn about it from my presentations. So after that, they know. So the ease is often actually the point of criticism, right? People who criticize geoblocking often say, well, it's so easy to circumvent it, why should we have it at all? Second point, what are legal implications of circumvention of geoblocking for users and providers of circumvention tools? In my first major article on this topic, I analyzed some of the grounds based on which users and providers of circumvention tools, meaning VPN providers, could be held liable for violations of different laws. There is a big question mark behind every one of them, of course, because we don't really know. There are very few cases out there. But the fact that the few cases that are out there are taking very long time to be resolved, such as the Spansky Enterprises versus Telewizja Polska litigation, or that parties surprisingly settle very quickly when these cases arise, such as the Global Mode case in New Zealand, perhaps suggests that I'm not the only one who has a huge question mark behind all of these. Localization of acts is, of course, very important in this case. Whether local laws are actually infringed by any of these acts will depend on how courts localize the particular activities. Certainly, a user could end up in violation of terms of service agreements, contract violations. Copyright law provides for a protection of technological protection measures, and under some definitions, certainly geoblocking tools could be perceived as such. So a user could be held in violation of those laws. Anti-hacking laws in most countries would probably not be violated by sort of a regular, everyday type of circumvention because of the minimal damage caused, arguably, by these activities. Now, circumvention tool providers, like any good ISPs, would be in much more danger of being exposed to liability, of course, much easier targets, deeper pockets, and so forth. In their case, again, I can return to this list during the Q&A. I would point out the last one. If you follow the area litigation all the way up to the Supreme Court, you might have noticed how careful area was to emphasize that they were not involved in circumvention of geoblocking, that they were only affording the services to people in New York, and there was a good reason for why they did that. Third point, what are the general legal implications of the circumvention of geoblocking for legal systems? Is circumvention of geoblocking actually only a negligible spillover? Certainly was 5-6 years ago, or is it today perhaps a widespread practice that actually leads to a significant erosion of territoriality? Now, if it does, which some people argue it does, what does it mean for legal systems? Should we simply abandon efforts to achieve territoriality because technological means, meaning geoblocking, have failed to facilitate territoriality? Or should we engage in some kind of regulation of this spillover? And here I would point out to another regulation that's being discussed in the European Union, and that's the EU regulation on cross-border portability, which might be perceived as an example of an effort to regulate this kind of spillover, right? There are many problematic issues about that proposal for the draft regulation, and I would be happy to discuss some of those problems during the Q&A. And I will leave you with a list of recommended reading. Thank you.
Mike. No.
Oh, now we're a little better, much better. In honor of the election season here in the United States, I'm going to out myself as a flip-flopper on the issue of geoblocking, because I have been against it, and then I've been for it, and I've been against it, and I've been for it in different contexts. And I thought I would sort of walk you through how that happened, and maybe there's a consistent narrative line. But when I was, when I was general counsel at Wikipedia, which is an international project, one of the things that we would ran into quite early on was different governments were objecting, or people in different countries were objecting to content on Wikipedia, and they kind of wanted to use legal systems local to them, ideally, to shut down content and to have content taken down under the various rules of their local jurisdictions. And so one of the things that happened, we had German murderers trying to shut down content on Wikipedia. We had Silvio Berlusconi tried to pass a law in Italy. We had French efforts. The French go of two minds on this at various times. And one of the things that we did, because Wikipedia was a very community-driven project, because Wikipedia could not exist were it not for the community of users who were contributing to Wikipedia, we were quite careful in thinking about how we responded to this stuff. But one of the things that we did was we knew that it was at least theoretically possible if a country passed a bad law, we could block that country in protest, and we would do that only with consent of the user community and after consultation with the user community. This was never a top-down decision. It was always very consensus-driven, as I'm sure will be particularly appreciated by those of you who are in multilateral processes in the EU and so on. We were very consensus-driven. So we were kind of for geoblocking. So when Internet Watch Foundation blocked Wikipedia, or actually didn't block it, they put us through a proxy that made it impossible for UK citizens to edit Wikipedia, which, you know, depending on how you feel about UK editors, that maybe that was a good thing. But But because we allegedly had child pornography. And the Internet Watch Foundation was a hugely unaccountable, still is, hugely unaccountable entity in the United Kingdom that addresses child pornography issues. And the issue there was an album cover for an album called Virgin Killer, which was arguably qualified as child pornography under one definition or another, which appeared on Wikipedia. And we didn't actually geo-block the UK, but we thought about it. Because we thought about enabling the English Wikipedians to block, to geo-block as a matter for protest, Wikipedia in the UK. We thought that would draw some attention to policymakers that maybe the Internet Watch Foundation had done something wrong. And so I had been, during my time as general counsel, I had had this idea that protest, this is a very effective protest because unlike shutting down, say, Reddit, shutting down Wikipedia actually has an effect not merely on policymakers, but on policymakers' children who are trying to do their homework. And so we knew that we could sort of, if we did shut down Wikipedia as a protest, that might be helpful and have an effect. And ultimately, there are different initiatives in Germany to do it. The German Wikipedians didn't want to do it. The French Wikipedians, it turns out French like to go on strike sometimes. And so they kind of did want to do it, but we resolved that issue in France before we ever got to it. But the Italians actually were the first people who did a Wikipedia blackout, and we supported the Italian Wikipedians doing a blackout. And then, of course, we had SOPA in the United States, and then we did geo-blocking in the United States to block for a day, for a 24-hour period, Wikipedia content with a protest, and we had a protest message. And of course, like all geo-blocking that we know of today, you could defeat it. You could use a VPN or Tor, although interestingly, some people in other countries who were supported our blackout of Wikipedia in the United States also blacked out and geolocated. The Wikipedians also blacked out in support, so it was very, very heartening. So I was sort of for geo-blocking. At the same time, I was against it. Because the fact is, the People's Republic of China has blocked Wikipedia off and on. Sometimes they turn it on, like for Olympics. They want to be open, but then they decide they want to turn it off again. And other countries have made different efforts to block Wikipedia. And the fact is, I was very, very influenced and lucky enough to be at EFF and to know David Post and David Johnson before they were talking about cyberspace as a jurisdiction. And one of the things that I've had the benefit of is having sort of watching this issue of developing and exploring the idea of what it means to have cyberspace as a separate jurisdiction. And what I knew was, even then, back at EFF, when I was working at EFF, which I did for 9 years, I think that David Post's assessment of the paper is quite sound, which is that I think that they identified real problems, and then the solution, which they proposed, which is cyberspace as a separate jurisdiction where the fences or borders are really passwords or some other kind of permission-oriented space, I think doesn't work, because the fact, at that time, I think the model for online interaction, public interaction, may have been America Online. There were all these sort of different spaces where you got a membership and you could be part of it. It was a voluntary association. That didn't seem to me to be where the internet was going. I thought that the internet was going to be much more open than that. And so people, in fact, people use Wikipedia without logging in. People could edit for a long time Wikipedia without logging in. People use Google and stuff and other applications in different jurisdictions, regardless of where they happen to log in. And I think that we actually have benefited from that quite a bit, from the openness. So in that sense, I'm against geo-blocking. So what's the rule, Mike? The answer is, I think it's okay when it's part of a voluntary association, a voluntary decision from the stakeholders within an entity to geo-block. I think it's okay certainly if they're protesting what national governments are trying to do in terms of shutting down content. And certainly if they were protesting what a multilateral treaty organization was trying to do, it would be appropriate to geo-block just to register your objection to that policy. I've worked on, and I'm glad we have only 7 minutes because I would just totally I'm going to run out in just a minute. But I think one of the things that I've learned about this is that we're still sort of applying the old paradigm, which is the idea, and this is true of David Post and David Johnson's paper, and it's true of the discussions here a lot. We apply the idea that, in some sense, geographic location should be our guiding line. And I think ultimately we may find that that's not productive, and ultimately we may want to find a different principle that guides us, which may be grounded, I find it well articulated in the American Supreme Court decision, Katz versus United States, which is that the privacy protections of the Constitution protect people, not places. And so I just want to leave you with that, and I'm sure I can unpack some of this in our commentary period.
Well, that's actually a very good segue, Mike, because what I wanted to do to start the conversation off, or the discussion with everybody, is to sort of seize on something that was in one of your slides, Graham, about this sort of tension or balance between geo-blocking and global removal. And wanted to talk about, really, what we didn't sort of cover in this is that, and folks in the audience from the internet companies will know this, is that geo-blocking is really what you're trying to avoid when it comes to protecting speech, is to avoid this global removal problem, right? So in the early days of Google, we clearly targeted Google toward different countries with different languages and different domains and so forth. And so if someone didn't like, if something violated the laws in France or in Germany or so forth, we'd remove the offending material from google.de or .fr, but it would stay up on google.com. And this sort of regime, I mean, just to be clear, this regime prevails today, and for the most part handles this territorial problem quite well. And the nice thing about it is that you can sort of comply with the law. At the same time, the user then has, and I know, Graham, you've written about this a bit, the right to travel, if you will, right, in terms of seeing, and the reason that, then the thing that makes this possible is the fact that the default for the user is the local experience. And it's actually interesting that these defaults are actually quite powerful, right? And so if you're enforcing a law in a place, what you want to know is that the law is actually working, and that for the most part it's having, if the issue is, well, this content's really bad and it violates our laws, what you want to see is that the people in your country, for the most part, aren't seeing the content, right? And this actually works because if the initial experience is a local experience, and if to go outside that, you have to do something. Now, it may just be a click, it may be a series of clicks, it may be you're doing something. Then the vast majority of people actually don't do it because they like the local experience and they do it. So we've at Google, we always have had this. We've always pushed very hard for this regime, because this regime preserves that freedom, that right to travel, while also allowing local law enforcement to actually make sure that, for the most part, the laws actually enforced. Now, geo-blocking, on the other hand, you could say does the same thing, but it because it doesn't deprive the whole world from seeing the content in places where that content is perfectly legal. But what it does do is it eliminates this right to travel. I guess I would argue, and the reason that's the reason we've always resisted geo-blocking. And in fact, for the most part, we've been pretty good. And the right to be forgotten has sort of eroded that. Google and Microsoft has had to sort of change the policy there under some duress. But I guess I don't want it to be lost on people to understand that there's another regime for handling these kinds of things, as opposed to just blocking content, that has worked very, very well. And I think it would be great to be able to preserve that.
Yeah, I want to follow up a little bit on what Andrew said in the last panel, which is that with regard to the right to be forgotten, he spoke for me as well. I think that history will not look kindly on democracies that erase history now. And the fact is, if you look at the right to be forgotten case, the Castella case, one of the things that you see is that was not a privacy case. That was a case in which there was a public action, compelled publication of a government action against a private individual, and that's also available on the newspaper database. But the fact that it was available on Google, on Google's search product, was quite troubling to Castella. Now, the thing that troubles me about this is that if you want the internet to do anything for you, if you want search to do anything for you, you certainly want it to protect our right to recover what has happened historically, what government action has done. And I would actually say that this is a human rights imperative, because, as you know, for all that Article 12 and various in the Declaration of Human Rights and the ICCPR protects reputation, there's also Article 19, which reflects everybody's right to seek and to impart information. That is a freedom of inquiry protection, not just a freedom of speech protection. It's all there. You have the right to look stuff up, and you have the right to find it. And you have a right to know your own history. So I think that with regard to the right to be forgotten, it's really important that we think very precisely about that. And I am just as head up about it as Andrew is, and as I know many of you are. And I look forward to our French regulators making a more nuanced case for the right to be forgotten.
Marketa and then Graham, but we're going to litigate right to be forgotten later. So let's stick to, and I do want some feedback on why would we use geoblocking for this sort of content regulation enforcement of local law when we have a very good alternative, which is targeting people, and then for the most part they use the local experience. But you can address what you want to address, but I really want to hear some thoughts from the panel there.
Thank you. So one of the issues that I see with geoblocking is that it has been vilified, when in fact people, many of them feel like Mike, and I certainly feel the same way, which is there are situations and places in which geoblocking should be used and has legitimate purposes. Mike and I might disagree when those circumstances might arise, but I think geoblocking is a technical tool. It's just like a lock on my house. I know that somebody could put the same lock on a polling station on November 7, and that would be problematic. But it's not problematic to have it on my house when I leave and want to, I don't know, prevent the stupid burglar from getting in, I guess. So geoblocking is the same thing. It's a technical tool that can be, of course, misused as any other technical tool might be. So again, I think that the vilification of geoblocking is problematic. Going back to David's point about, let's take it down from google.fr and that should suffice. As far as I understand, Google actually agreed to geoblock for the purposes of enforcement of right to be forgotten.
Yes, that's what I was alluding to.
So now it will be taken down from google.fr, google.com. In Canada, the acoustic decision is now being appealed to the Supreme Court of Canada on the same point, right? In a trade secrets case, Google was asked to geoblock all users connecting from Canada to access certain results. So that's now before the Supreme Court of Canada. So we will see what will happen with that. And finally, on your point about right to travel, in my 2012 article, I actually explored this kind of argument too. The problem is that frankly, right to travel, certainly within the US, it's a constitutionally protected right. But when you travel internationally, that's a different matter. There are limitations. As many Americans recently found out, you do need a passport when you travel abroad. So there are certain limitations. Again, we might argue what kind of limitations are appropriate in which situations, and that's up for a debate, but there are limitations.
Right, but I think one of the points that people don't, the missing points here is that that with this sort of right to travel approach where you don't geoblock, it's actually as effective. I mean, the European Union actually, a lot of people don't know this, but when Google was negotiating this settlement that never went through for the competition law issues, there was this question of, well, this is a European we need to craft a European remedy, and how would you do that? And one of the things you could have done is to geoblock, right? The commission actually agreed that, well, we don't need to do that because they got convinced that the defaults were so powerful that it was only a very, very small fraction of people would actually, go outside the local experience. So there you have, European Commission actually, it never went through, but they had accepted that principle. And I think it's important, to understand how you're not getting a lot more law enforcement by geoblocking because, of course, the circumvention tools and so forth can get you around geoblocking as well. So all of these things have leakage. And the question is, do you want to have, if it already has leakage, why not have go for the solution that protects the most freedom?
Yeah, I was interested in your comment that the local experience targeting approach works well, but that obviously begs the question of by what standard does it work well? If your starting point is that the citizens of your country should not in any circumstances be able to access content of a type which has been decided to be illegal in your country, whether they are within the country or elsewhere, then targeting doesn't work well. But then the issue then is that a reasonable stance for a country to take when in the physical world their citizens can go to other countries, can travel to other countries. In the UK years ago we had the spycatcher litigation. There was a stream of people going from the UK to America, reading Spycatcher, buying copies of Spycatcher, which was injuncted within the UK, couldn't be read in the UK. They were even bringing copies back. And no one in the UK thought it was, if anyone suggested that people coming back from the US should be prosecuted or subject to some kind of sanctions because they had read Spycatcher while they're in the US, that would have been, I'd like to suggest, greeted with some ridicule. And when you translate that into the internet and cyberspace, that's when you get into this issue that by taking that position, you're actually building much less permeable borders in cyberspace than you are in the physical world, which is why I put the picture of the Berlin Wall up in my slides. And what is underlying all this is the need, or some of us would say the need, for jurisdictional restraint and not trying to impose a monopoly of your local laws on your citizens, and accepting that the internet challenges, if there is a view that your citizens should only ever access content made under your own laws and never under the laws of any other country, that is challenged, and that an attempt to replicate, attempt to prevent that actually is far more restrictive than has ever been the case in the physical world.
I want to...
Wait.
Sorry, go ahead, Joe. Joseph, you
My turn. But anyway, so in addition to not getting a whole lot more law enforcement, in addition to some of the stuff Graham talked about, from the technological perspective, the things you need to do to people in order to get the level of granularity you might need really are things we shouldn't sort of make a default. There's a whole bunch of things that we didn't build into how these technologies work. You don't need to have some highly granular notion of location before you can send a packet on the internet to communicate with anyone. We did that for a very good reason back in the day, because it was we didn't have the tools to do that. But I just want to not equate, but at least point out that there are things like DRM in the intellectual property space that try their best to sort of ratchet that down to where you make it as hard as possible for as many people as possible. And I really think that's just a deficient way of thinking about how the internet should work, and it imposes particular obligations on folks who want to make sure that we have all the knowledge in certain places, be it Wikipedia or be it Google.
One of the things that the law professor Julie Cohen has written about this on copyright. She remarked that one of the things that makes copyright work is the fact that it's loose. It's not totally locked down, so that you can engage in fair use or fair dealing with regard to copyrighted works. And if you do it, and you're not sort of categorically assumed to be a felon or assumed to have done something else wrong for having done that. I mean, the system properly implemented, copyright systems are somewhat humane in allowing people to use copyrighted works. And so I think that model is actually kind of useful to think about, whether it's reputational rights or anything else. We want to have some tolerance for people, for people to, we don't necessarily need to have 100% effective blocking of objectionable content. And in fact, nobody knows what 100% effective blocking actually looks like, except to totally balkanize the internet. And I just want to comment, for those of you who haven't yet reread the Post-Johnson paper, one of the things that the authors did was they said, we see two possible worlds, one in which there's a lowest common denominator of enforcement of content on the internet, and the other one in which there's kind of a balkanization, they didn't put it this way, but a balkanization based on terrestrial jurisdictions. And of course, what we now see is both. things are happening, which is that countries are trying to enforce geographical jurisdictions, but also that French regulators or some other regulators may want to have global reach in what they're doing, a kind of a lowest common denominator problem, although I'm sure French advocates of the right to be forgotten would say it's the highest common denominator. But
So let's open this up for questions, discussion. We've got a mic here. I see Fred moving with alacrity here. So go ahead, Fred.
Question, I think in all of this discussion, we've already had a sort of preview of geo-blocking and circumvention tools. I'm curious what the panelists think is going to happen 2 steps on, right? Because we know that governments are trending toward blocking. We know that circumvention tools are increasingly being used. What happens next, and I guess from my position even more important, what happens next, right? Because I think there will be, particularly some adversaries, if you look at them that way, will be highly motivated. Gambling, copyright infringers, certain commercially motivated entities that are the target of some of this blocking, they're not gonna take that lying down, right? They will deploy a different set of strategies. And I'm sort of curious, where does this lead us down the road?
So it's happening now, and I didn't get there, but I think an easy way to sum it up would be if you want to target service providers or over-the-top or applications to block stuff, you're never going to be able to do a good job. And this is why the Great Firewall is extremely instructive. Right now, if I don't know, Mike may, but I'm not sure if anyone else here keeps track of what's happening with dissidents in China. But right now, even things like Streisand, which I showed you, which is extremely sophisticated piece of kit, it's just a whole lot of fun. Grab me sometime and I'll show you how it works. Are being blocked by machine learning. The Great Firewall is noticeably, we can't prove this, but is exhibiting elements of what we consider to be a machine learning environment, to where it'll let certain flows go for a day or two and then it will stop. And so I think, in the end, the people who have the geographic capture of people, including not letting them travel, for example, so you may not actually have the right to travel, I think that's where it's going to end up being. And I would hate to see a Great Firewall of France specifically for the RTBF concerns, but we could see that evolving right now, and it's very hard, especially for the lay people. This is the thing. Changing your DNS is one thing. Setting up your own VPN endpoint and understanding what all that stuff does and how to not, screw it up, which is important if you're a dissident or have some sort of, you could end up in jail or dead kind of a threat model in your. I think that's where it's going to end up being, because, they're going to have to spend a lot of money to do that kind of blocking, and China and Iran and Russia do spend quite a bit of money on these things, but I just don't know how you ever end up doing as good a job as what they're doing by targeting service provision, because service providers are never going to have the ability to know with a fine degree of granularity where things are, unless you have your ISP being the endpoint that you're trying to contact to, which gets a little, that's where my hand waving there breaks down a bit.
If I may, so 2 things, one on the future and one on gambling industry. I cannot leave this panel without talking about gambling industry. So as far as the future, in my 2012 paper, I explored the possibility of a digital passport, and going back to what Joe said, right, not going the route of the EU proposal for the regulation on cross-border portability, which will require Netflix to now follow me everywhere in Europe, not only to geolocate me at any given moment, but actually track how long I spent in which country, which I think is really problematic. But really actually going to a certain level of abstraction that we need to figure out where I am from, what kind of content I have available in my home country without necessarily identifying me as a person, right, as a particular person. So that's just for the future. Again, in my 2012 paper, I explored that option. As far as gambling industry, I, again, cannot leave this panel, being from the University of Nevada, Las Vegas, without talking about how much ahead of many industries the regulated, and I have to emphasize, heavily regulated online gambling industry is. Geoblocking is absolute standard in regulated online gambling industry. There is nothing to discuss there. It must be employed. It must be as effective as they can. In fact, in regulated online gambling jurisdictions, there is an obligation of foreign compliance, meaning if a gambling company that's licensed in Nevada allows its geoblocking to be so leaky that users from Utah can use it, they will lose their Nevada license for it. Because under Nevada law and Nevada regulations, the company has an obligation to comply with any foreign laws in any foreign jurisdictions where they operate. I think it's problematic that there is not a carve-out for human rights and other issues, right, where we would hope the company would adhere to some general higher standards than necessary local law. But I think that that's an interesting model that we might see replicated in other industries. Whether it is desirable and whether it will make all of you happy, I don't know. But that might be the future.
Marketa, how does the knowledge work there? Is it if they're doing everything they can, then you just happen to learn that they have a domicile in Utah or something like that? Like, can you talk about like
Knowledge of whom?
knowledge of the geographic targeting, or that they're gaming you to try and use services that they shouldn't be?
So usually what it is some kind of law enforcement authority of the other jurisdiction will notify the Nevada regulator about
Formal
this
knowledge,
behavior.
not like, oh geez, they filled in this form and put Utah in the state. Okay.
I don't know that.
So one of the things that I'm reminded of is Thomas Kuhn's book, The Structure of Scientific Revolutions. He basically says that old theories are abandoned not because they're disproved, but because all the people who hold the old theory die off. And then eventually you have another generation of people who recognize that the new theory might be a better fit. I think with regard to sort of the sociology of internet access, the arc of the arc of justice is a reliable thing, and the question is whether it bends slowly or fast. I think that when we have more and more nations experience the fact that freedom of speech and all the things that you can do, good or bad, with freedom of speech are mostly tolerable if you otherwise have a stable culture, then we'll still have carve-outs for things like gambling and child pornography, but the idea that you have to suppress something that is true but looks bad on your record becomes less important. That's sort of my hope. The experience in the United States was that way, and the experience in a lot of developed countries has been that way, that there's already, even in the countries whose regulations that we're objecting to, there's already been progress in those countries as well, throughout Europe, that tolerance of public dissent, tolerance of criticism of government, these are all things that there's much more toleration of than there was a century ago, and I think the internet is part of that development.
Okay, I was also reminded of something which was Cory Doctorow's article years ago, The Coming War on General Purpose Computing, in which he characterized this effectively as an arms race, and as authorities, states, rule makers, continue to fail to control activities they don't like, so they then replace that with ever more general and ever more intrusive regulation in a continuing futile attempt to achieve these objectives. So I think there is an element of that to this. What I hate predictions, and one of the things that I was really struck by when I was rereading the Johnson Post article was to look at which aspects of the article were descriptive, which were normative, and which were predictive. And one of the predictive aspects, which was repeated a few times, was that these efforts will prove futile, but what we don't know, of course, is over what period you're measuring futility. Are we talking about 1 year, 2 years, 5 years, 50 years? And I don't know whether what we're witnessing is the brink of a new era of a balkanized and carved up internet, or whether we are witnessing the last thrashings of the dinosaurs.
Daphne?
So geoblocking is one of several areas where I worry a lot that if we make law or policy based on what Google can do or what Google is motivated to do, we will, or what Twitter or Facebook or other sort of giant players in the space can do, we will arrive at laws of general applicability that really don't work for the whole rest of the internet and the many, many smaller actors that are out there. And with geoblocking in particular, it concerns me that if we move toward a norm that companies on the sort of server side, the ones hosting and disseminating information, are expected to engage in geoblocking, what happens to companies that don't have a whole bunch of lawyers who understand the law of every other country, who don't have fabulous engineers who can make very refined geoblocking tools? Will we arrive at a situation, for example, where a local online newspaper would simply block the entire rest of the world in order to avoid the problem? So I'm curious, first, whether you see that issue playing out in that way, but more broadly, what other unintended consequences that haven't come up so far do you see flowing from geoblocking becoming a norm, if it is indeed becoming a norm?
Boy, I love that question, because one of the things that we know that has informed efforts both to localize user data and also to and also in things like enforcement of right to be forgotten, and certainly the digital single market consultation, platform consultation, is sort of an assumption that, you know, American tech companies, if they're successful, they're probably doing something wrong, but it's okay to impose a burden. You know, we're a little suspicious of American tech companies doing stuff, but it's okay to impose a burden on them. But what I think the regulators are sometimes short-sighted about is that this actually cinches Google's dominance in search for 100 years, because Google has, and Alphabet have the resources to be responsive and to make discriminations among cases. They're well positioned to do it, but if you are a new market entrant, a would-be competitor to Google, the chances are that you will not be able to do that. You will not be able to fund legions of lawyers to do takedown analyses of copyright stuff, much less right to be forgotten stuff. It's hard. It raises the barrier to entry. So European regulators, if you want Google to continue to have a higher percentage of adoption in the EU than it does, even in the United States, you're on the right track.
Yeah, I mean, let me just chirp in on that too. I mean, I think there's a little bit of a failure, sort of a abdication of responsibility by these governments. Like, if you want things blocked, geo-blocked, why don't you do it, right? Why is Google adjudicating these right to be forgotten things and then has to employing these technical means to enforce this law? It doesn't make a lot of sense, and I think that a lot of governments look at this and they say, we don't want to be in the business of restricting speech through technological means, because then it makes us look like China. Well, there you have it. Go ahead.
So Danny O'Brien from EFF, and yeah, in that sort of space of careful what you asked for, to return back to what Fred was talking about and to ask what happens 2 steps down the line there. Right? Joe's right that what China's been doing is essentially blocking protocols at this point, detecting and blocking that. But in hand with that, what happens if you block protocols? Well, you block legitimate use of circumvention or VPNs. And you also have to go after the people who are crafting those protocols. So what we see in China is the arrest and harassment of individual technologists, so those are the small actors that Daphne talked about, and for the larger actors, the commercial VPN providers, a licensing regime in which you're allowed to provide the legal sort of overriding of geo-blocking, but you have to provide information to the local government. And I think that's possibly the next step, is the carrot and the stick, is that the larger providers, both the people who are going to facilitate geo-blocking and the people who are going to provide things that, as a side effect, have a way of evading that, they'll be dropped into a licensing regime and actually be part of the enforcement mechanism. And then you'll get this pressure on small actors who might be agile enough to dodge the regulations, and they'll be criminally targeted. And this was something that we saw an attempt at in the early 2000s with intellectual property, where the idea was, well, maybe we could arrange a licensing agreement with you as long as you chase out of town these young disruptive technologists. It didn't work there because I think the IP providers couldn't manage the licensing. It was too much of a legal mess to be able to do that, and didn't really realize what the costs are. And I don't think that's true of governments now. I think they understand the benefits of regulating the large actors and disbanding and chasing away the small actors. And I think it's notable here that everybody here, I think, is either veterans of that time where maybe we temporarily won, or are now large actors. And I'm really concerned that the small actors are both not here, unaware of what's going to happen, and I think they're the people who are going to bear the burden. That was one of those points masquerading as a question, so maybe just assume that there's a question mark at the end of that. Yeah.
Certainly the pressure that's put on developers, like the guy behind, I forgot his name, behind Shadow Socks, which is one of the really coolest new ways to get through hostile networks. It's really unfortunate. I think, and what you're seeing is there are really, really gifted technologists and developers in some of these regimes who are going to have to do their best to remain as anonymous as possible in like ways that are beyond just network anonymity, right? And that's really unfortunate. To the extent we can help them, gosh, we really should, because some of that stuff, people who don't have the needs that they have don't think about the solutions that they think of, and they're just really beautiful things. But anyway.
If I may just say a few words, I have been calling for addressing legal issues of geoblocking and VPN circumvention of geoblocking for a while, because I think they should be viewed as neutral tools, and we should clarify the law so that people don't have to be worried about legal implications that might be negative of using them. Going back just briefly on the Google point, as the only European on this panel, and as apparently maybe the only person in the room who actually grew up behind the Iron Curtain and remembers what geoblocking meant.
We've still got about 6 months, right?
Right.
He's still in now. I mean, he's in there now.
I think that that might be up to a debate, actually. But I mean, I think it's important to realize that what we really want, right? Or do we really want countries to go the route that David suggests, that, hey, government, if you want to block it, do it yourself, spend the money, don't impose it on players? Or do we want players, actors on the internet, to actually have a choice? And if I believe that if there's anything important in the story is the possibility of a choice. So going back to Daphne's point, right, small local newspaper, small local broadcaster, if you tell them you must not geoblock, that means de facto, if you want to broadcast, reprint content of somebody else, you have to have a global license. I think that the cross-border portability regulation, I hope it will actually become effective, because we will really be curious to see what the effects of that are in Europe. It might kill a lot of small actors on the internet, small papers, small broadcasters, who will not have the resources to pay for EU-wide licenses, and there will be no alternative for them. It will be either you pay this much for a global license or EU-wide license, or you will not exist, right? So if you don't give them the option to geoblock, they might actually be gone, and we might end up with these huge media conglomerates that will manipulate the prices of licenses so that they price out smaller players. And I don't think that that's a result that's desirable either.
I should confess that I'm a geoblocker. I block most of China from my website, and that's just because of bandwidth reasons, and I'm really sorry, and I'll turn it off. But but it's different than licensing. I think there are other kinds of operational things that are probably in the weeds, too.
Well, you know, it's interesting, but it's interesting. I think one of the things this underscores is that governments, and I think the more progressive governments have this in common with the less progressive governments, which is that they have government prerogatives. They want to be able to have user data in their country so that they can arrest people when they want to. That's the real reason that they want data localization, and there's no other story for data localization that makes sense except that one. It's really about the ability to arrest people. But if we believe that the economy and the benefit and the democratic benefits of the internet are things that are important, then we want new players. We want the successor to Google or the successor to Apple or the successor to other giants to be able to start small and get big. That's a better world. And I think people even in the big companies believe that. They've benefited from being the first market entrant, that they would like to see things be able to be shaken up from time to time.
Great, go ahead.
Hi. Thanks. Andrea Glorioso. I'm not clear whether I'm speaking here on behalf of the Euro on a personal basis, just to be on the safe side, express personal views. And I'm Italian, not French, which apparently this conference is a point of honor. And no, that I'm not laughing about that. I think there is a little bit too much attacks on what our French cousins are doing. But in any case, this has been an interesting panel. I basically disagree with everything that you have said, or mostly. But I want to zoom on one point, which has actually been raised by Daphne in her question, and I remember discussing it with Daphne a few months back. We get it, and now I'm not speaking personally, I'm speaking as an official of the Commission. We get it that applying the same rules to a 10-person company as a 1,000-person company, as a 10,000-person company, doesn't make sense. And we get it because we have been doing that for 50 years. In almost every single area of law, you do not apply the same obligations to differently sized companies. You apply de minimis rules or whatever you want to call them in the banking sector, in the environmental sector. I'm not going to list all of them. Now the question is, and this is true in Europe as in the US and in other countries, I assume. Now the question is, when we come to issues such as geo-blocking, or in general, how do we regulate these very complex issues, can we have a discussion, is industry, globally, not only US industry, are we ready to have a discussion whether we could apply rules differently depending on the size of the company? Because size define, and I'm ready to admit that the criteria through which you define what size means is up for discussion. But are we ready to accept that? Because I must say, I have personally been raising this point for 2 years since I've been here in the US, and I have not heard any willingness to even discuss it. Now, one might be tempted to think that what some players around the table here are actually doing is defending a point of principle, which is actually good for their bottom line as well, which is fine. They're commercial companies, no problem. But as my French friend Bertrand has said, nostalgia is not a project. So I think industry has to make a choice. Either we continue to say that no matter what, we will not accept any regulation because there might be spillover effects, there might be negative effects. We don't have that luxury. We don't have the luxury to simply not do anything because there might be potentially bad effects. So sorry for being very long, but I'm also Italian, so I think I'm justified. The question is, are we ready to have a discussion whether we could apply at least some of these rules in a different way depending on the size of the company, and would this meet potentially some of the concerns that Mike, among many others, has raised? Thank you.
Yeah, I'd like to respond to that quickly.
Okay, sure.
Coming from one of the big companies,
Right.
I think we'd certainly be fine discussing that, but I'm not sure what it accomplishes. If you take what right to be forgotten or some of the other things that are the sort of the bleeding edge of content regulation, it's about enforcing someone's rights or protecting someone's rights. In the case of right to be forgotten, a very particular individual privacy right. At least that's what we're being told. It's not clear to me why that right is infringed less because it's a 10-person company as opposed to a 60,000-person company. So I think really the issue is it's the more substantive issue.
I'd like to react to this immediately.
Andre,
If you allow me,
let me
Mike, just a moment.
all right.
I want to react to this immediately.
All right.
Obviously, a right is a right. But let's face it, because we are not stupid, unlike what some people in this room are starting to suspect things, we are not stupid, which means that we don't actually care what happens in a 10-person company as long as the effect is not massive, which is why I said that the criteria to decide what big means in this environment is up for discussion, because you can have a 10-person company which actually has a massive effect on the rest of the internet. Perhaps it was my mistake to use number of people as the criteria. There are different criteria. But the point being is that in every single field of law on policy, you try to intervene in the areas where you know that the effect of positive or negative effect is going to be massive. That's what you do. In this sense, this doesn't change the fact that the right still exists, but in practice, and I think we need to be a little bit more practical at this point, in practice that makes a huge difference. And that doesn't change whether we're talking about Google or about any other company, which is why I didn't mention any specific company in my point.
Let me. I was with Wikipedia when we were a top 10 website with only 10 people, or fewer than 10. So we were a 10-person company that was the number one, a 10-person enterprise that was the number one encyclopedia in the world. And my reaction, because I'm a little perverse, is that I would love it if we said, 10-person companies or 100-person companies get a pass on right to be forgotten. because I actually think that one of the things that you articulate, Andrea, which is that you're worried about what the effect is, mistakes what really can happen on the internet, which is that you can have what is technically a small company have a very, very large impact. So you can't really say that a small company on the internet can't affect someone's reputation worldwide. That's certainly not true. The fact is, the architecture of the internet empowers people with small amounts of resources and with small staff to have worldwide effects. That's one of the things that we have kind of liked about it.
This is going to be the last question.
Thank you. Thank you. So, in addition to looking at it on the forgotten side, there's also the collection side, where all these people that don't want to be collected. And their big problem is the collector from the collectors, namely the national intelligence agencies, doing this massive kind of collection that has been exposed and trying to put an end to that. And the problem is verification. It's like what Reagan said, trust but verify. How do you verify that the collection, the massive collection, has ended by these, that's been demonstrated by these intelligence agencies, given how hard it is to audit these big distributed data centers? How can you possibly verify that? But they really want to see it verified. They want that to come to an end, the collection side of it. So how can that possibly come to effect? In that respect, the recent Yahoo case is very troubling, because it's been revealed that even though the Yahoo security boys weren't informed that their company was doing this, management decided to yield to the collection secretly. And so what are the Europeans going to say to that in terms of the new data protection treaty that we're supposed to be negotiating with them?
So I don't think,
Just say something on that. I mean, we have agencies in the UK as well who are every bit as keen on collection as your agencies.
OMG.
And we have trouble domestically verifying what they're up to. We have a 300-page bill going through Parliament at the moment, which is a response effectively to Snowden and certain other things, which is designed to try to bring it all into the open, to have oversight and so on. But it is a difficult problem domestically, let alone cross-border.
yeah, and I'm not sure you can verify, and I'll answer this in a very indirect way, which is there's this wonderful documentary, and I can't remember what it is, but I can't remember the title of it, but it involves a Muslim community, I think in Ohio, where there's this lore where they've been under FBI surveillance for many, many years. And it turns out, the documentarian found out that they were under FBI surveillance, but it has now stopped. And so the whole documentary is about trying to talk to people about, can you live your life differently now that you're no longer under surveillance? And there's nothing you can tell that community that will prove to them that they're not under surveillance. And of course they are. It's just a different kind of surveillance. So I don't know if there's any way to provide that kind of assurance. And that's why
You can always call in the engineers.
Well, I mean, we're really good at hiding things from each other too. So anyway, yeah, I don't know if you can do that. And then this is why the Schrems and the Privacy Shield, all that's going to just fall apart.
China now has a whole regime that they impose against foreign companies for this reason, requiring audits against backdoors.
Yeah.
Okay, great. So I think we have to go to lunch, be told. So with that, we'll end the panel. So thanks very much, panelists and discussion.